Hello members, welcome back to Agora Legis, the platform of legal minds, where we discuss legal principles and make them easy to understand for everybody. Today we are diving into Contract Law 1 and we shall talk about the concept of an offer. We shall define an offer, we shall give the legal nature and importance of an offer, we shall give the essentials of a valid offer, and finally the types of an offer. Without further indulgence, I'm Counsel Ben and let's jump right in. According to Section 1 of the Contract Act Cap 284, a contract is defined as the willingness to do or abstain from doing anything expressed or signified by a person to another with a view to obtain assent of that person to do that act or abstaining from doing that act. A second definition has been given by Sir Gwenter Trillet, who said that an offer is an expression of willingness to contract on specified terms with an intention that it shall become binding as soon as it is accepted by the offeree or the person to whom the offer is made. After defining the concept of an offer, we shall now look at the legal nature and importance of an offer. And firstly, an offer is the first point in the contract format. We all know that a contract is first formed by an offer. We go to the acceptance, capacity, consideration, and lastly, intention to be legally bound. So an offer in its essence is the first point of a contract format. Secondly, an offer in its nature and importance is an evidence of consensus ad idem. Consensus ad idem is the point of meeting of minds in a contract. So an offer is brought up to show the evidence that this is what I proposed in this particular offer, and this is what you were meant to accept or deny in this particular offer. So as long as you can provide the original offer of a contract, you can bring evidence of consensus ad idem. That said, members, after looking at the legal nature and importance of an offer, we are now going to look at the essentials of a valid offer. What makes an offer being valid under the law? What are the requirements for an offer to be valid and legal, not to be void or voidable? So here we are going to see that the first point is that an offer must be clear and certain. Court will not enforce vague promises, as it happened in the case of Gibson versus Manchester City Council. In this case, the City Council in its statement was saying that the council may be prepared to sell. The court held that this statement was lacking commitment and certainty, and as such, it could not amount to a valid offer. So when you are making an offer, you have to make sure that your words are clear and certain. They are not ambiguous, because any ambiguity will amount to nullity of that offer in particular. Secondly, an offer must demonstrate an intention to be legally bound. Once you are offering something, once you are proposing an offer, once you are willing, as we defined the offer earlier on, we said that an offer is a willingness. So once you have suggested that willingness, you must have that intention. It must demonstrate that intention that you want to be legally bound by the terms of that particular offer. Thirdly, an offer has to be communicated. According to Section 2 and Section 3 of the Contract Act Cap 284, it provides for communication of an offer. And as such, we see that communication is one of the key points while talking about the concept of an offer. Because an offer that is not communicated is just a mere wish. Someone wishing for something. You just have an idea in your mind and you'll be like, I feel like I should enter into this agreement to sell the phone of my dear brother. Like my media guy who is here, Mr. Elisha, we greet him while passing over. If I'm not trying to communicate to him that I want to buy his phone. I want to do this and this with him. If I do not communicate, it does not amount to a valid offer. It is just a mere wish that I'm having, and never can it have legal power or legal force, and it is not enforceable. And lastly, an offer has to make room for acceptance. An offer has to be able or capable of acceptance. If an offer does not leave room for acceptance, it is not a valid offer. It is just a mere invitation to treat. In the next video, we shall be talking about invitation to treat in its depth. But right now, an offer that does not make room for a valid acceptance is just a mere invitation to treat. What am I trying to say here? If an offer is just a statement that requires further negotiation, it does not amount to an offer. It is just a mere invitation to treat, where you invite the other party to come and treat about a given matter, to come and embark upon negotiations. But an offer, for it to be valid, it has to make room for a valid acceptance. And the last point of our discussion today is types of offers. What are the types and the different categories of offer that we have? We have express offer. What do we call express offer? This is an offer that is expressed through spoken words or written words. It is expressed fully, and anyone can tell that A is proposing something to be in this way. It is not just abstract, but it is physically expressed and makes room for acceptance. For instance, in the case of Carlyle vs. Carbolic Smokeball Company Limited, in this case, it was an express offer because it was fully expressed in the newsletter that anyone who consumed their product and contracted influencer would be rewarded. So this is just a clear example of an express offer. It's an offer that is expressly made without any ambiguity. Secondly, we have an implied offer. An implied offer is an offer that is made without expressing it directly. It is indirectly said that I'm offering you to do this. For example, a passenger that is entering a taxi is impliedly offering to pay for the fare, because it is not necessary for him to speak and to say that I'm going to give you money if I enter in your taxi and you give me the ride up to this place. So a passenger, that is an example of an implied offer. In third position, we have a specific offer. This is an offer that is made to a particular person or identifiable group. So once an offer is not made to just anyone, but is made to a particular specific, for example, for contracting with my media team here, I had to contact them personally. I could not contact just anyone, but because of their quality of work, I had to contact them personally and to contract with them for the work. So it is not also, so this means that an offer has to be made for it to be specific. It has to be made to a specific person or to an identifiable group. We also have what you call general offer in fourth position. This is an offer that is made to the general public. Maybe it might be a unilateral offer for a unilateral contract. For example, in the case of Carlyle vs. Carbolic Smokeball Company. For example, I might say, as an example just, Agora Legis Foundation is offering to pay a reward of 100 Ugandan shillings for someone who subscribes to the channel, for example. So anyone who does it in the public, as long as I had the idea and the intention to be legally bound by it, it becomes a general offer. And anyone who accepts, whether impliedly or expressly, is entitled to whatever I proposed as consideration. In fifth position, we have what we call a cross offer. What do we call a cross offer? This is an offer for two people who have the same objective. For example, these are two crossed promises. If I and my brother Elisha, I was having the idea of buying his camera at 800 Ugandan shillings, at 800,000 Ugandan shillings, and he had the same idea of selling it to me at the same price, and we come and offer to act on that in that line. That is what we call a cross offer. And lastly, in types of offers, we shall look at what we call counter offer. This is an offer that comes to counter another offer. For example, in the case of Hyde versus Wrench, it happened. This is an instance whereby the offerer brings the first offer, but the offeree comes with a second offer to counter the first offer and to bring up a new contract. So, for example, you are going into a shop to buy a suit, a tailor shop to buy a new suit, a customized suit. If the tailor told you that you are going to buy one suit at 1 million Ugandan shillings, but you come with your second offer to buy it at 800 Ugandan shillings, this is what we call a counter offer. It is a second offer that comes to counter the first one. So members, these types of offers are not all, because we can have other types, but the main ones are these ones that I've just cited out for you, because most of the others fall under the ones we have cited in the current video. In conclusion, members, we have seen the definition of an offer. We have defined it according to the Contract Act, but also Sarah Gwenter. We have seen the importance or the nature, the legal nature of an offer. We have seen the essentials or the prerequisites for a valid offer. And we have seen lastly the types of an offer. I urge you to like, subscribe and share. And also, if you have any question, do not hesitate to ask it in the comments. Thank you for watching. It is Agora Legis with Councilman.